We're talking about the shocking turn in court today in the trial of Aiden-Fucci. He now says he did it. He's guilty of stabbing to death his classmate, Tristyn Bailey, in St. Johns County. The teenager's body was found in a woods on Mother's Day back in May of 2021. This case has upset so many people. So let's dig into what happens next. Shannon Schott is a legal analyst here for us, and she is an attorney and an expert on juvenile law, and we appreciate your being with us. This dramatic change, this announcement in court today, is it possible it would give Fucci a lighter sentence?
Not necessarily. It could be considered as mitigation or good information for the judge when he ultimately sentences Aiden-Fucci, as saving the family from the added trauma of having to go through the trial.
So let's talk about remorse. You're saying that is very, very important, and I'm sure you all have seen, we're about to play for you again here. The only statement from Fucci in court today, it was very short.
Mr. Fucci, is it your desire to enter a plea of guilty to one count of first-degree murder?
Yes, sir. And I'm sorry for the Bailey family and my family.
So that was the entire statement. It was very short. How important is convincing the judge that you are truly sorry? And do you think that was a good start or maybe not?
Whenever you're sentenced in Florida, remorse is not allowed to be considered unless the defense raises the issue. I think making that decision to say I'm sorry, and maybe the defense attorneys weren't aware he was going to say this, but saying you're sorry raises that issue, and now you've kind of started the sentencing hearing off on this path of remorse. It will be very hard for the defense attorneys to fully help Aiden-Fucci articulate sincere remorse in this case, because let's not forget he's been incarcerated, his ability to communicate is maybe not as strong, and that will be an uphill battle for the defense to really show sincere remorse.
So in this case, not a particularly great first impression, you're saying?
I don't know that I would have advised him to make that statement, and I think if there was going to be a statement, it needed to land a little bit more. There's a question about the sincerity of the statement that was made.
So we have already seen Fucci doing some things that are questionable, if not contrary to I'm feeling sorry for you all. And one of those was in the back of a police car. Now, this was a Snapchat video that was posted, and the text message, the Snapchat message said on the screen, "Hey guys, has anybody seen Tristyn lately?" And this was after, now we know, that he stabbed Tristyn to death. He also talks about having fun in a police car. So how does the defense deal with that type of stuff that's already out there on social media, and will the judge be showing that if he hasn't already seen it in the sentencing hearing?
Absolutely. The state's going to show over and over that Aiden-Fucci is not remorseful, but to that point, the defense would need to show why maybe he's not able to express remorse, or maybe there's some issue in his past through the testimony of experts who have analyzed him, who have interviewed him, and perhaps provided treatment. And as we know now, he is on antipsychotic medications, antidepressant medications, and there's certainly going to be a question as to whether he has the capacity to show remorse.
Let's talk a little bit more about this sentencing hearing. For one thing, on the 23rd of February, it's not going to be all decided that day, right? It's more like a procedural thing.
From what we understand, they're asking for at least 2 days to have the hearing. So yes, I don't expect it to happen on the 23rd.
And it's a lot of preparation, you say, for the defense.
Absolutely. The defense should be gathering mitigation, or that good information that we talked about, from the day he was arrested. They're going to tell the story of Aiden-Fucci's life, the good, the bad, the ugly, and try to make arguments as to why he should be entitled to rehabilitation through a juvenile sentence, or if he's sentenced as an adult, that he should get a lesser amount of time. But also they're laying that foundation for that 25-year review that he's going to be entitled to make sure that when he's reviewed later, the court has that information to consider, like whether or not he was abused or neglected as a child.
And so that has to be set in a court record now, and it can't be brought up again then in 25 years and say, oh yeah, by the way, he had a really tough childhood.
It should be part of the record evidence at the first sentencing hearing in order to make sure that when it comes up for review, that record is clear, that this is not something that's just being argued at this point.
So what else could we find out in the sentencing hearing that we didn't find out from, since the trial never happened, but in a trial you always say is, did he kill her or did he not, and then that's it. What else could we find out?
You're going to hear a lot about his mental health issues, his behavioral issues, the story of his life, like I mentioned, the good, the bad, the ugly, his home life, his school records. Who is Aiden-Fucci? How did we get to this point? And is there an argument to be made that he maybe shouldn't get the maximum sentence? And then, of course, the state will bring in all of that inadmissible evidence that we probably would not have heard at trial that really hammers home the arguments that they and the sheriff have made. And I think the word that they used was monster at one point.
So to answer some people's questions, I still hear people today saying, is there any chance that he could So just maybe go for a mental health or incapacitable, or what word am I looking for?
Incapacity.
Incapacity, right, thank you. Can he go for that, like the insanity defense, or is it too late?
It's too late at this point. Whether or not he's competent to proceed could potentially happen between now and the sentencing hearing. It's unlikely that will happen, but if at a later date when he's under a sentence he becomes incapacitated and incompetent, then he will be treated through whatever department is currently housing him and given mental health treatment.
And because he's a juvenile, the death penalty is totally off the table. That's not going to happen.
Totally off the table.
So let's go back. 2005, the Supreme Court said that juveniles cannot receive the death sentence. But since then, a lot of things have changed. Florida court cases have been involved. And what do you do if a child, a juvenile, is sentenced to life in prison? Talk about that. Yeah,
so in 2005, the Supreme Court basically said we don't execute children in the United States. And since then, there's been many cases that talk about the procedure, the proper procedure, and who can get a life sentence as a juvenile. It's really only the most culpable individuals in a homicide. So at this point, we have so much legislation and so many laws on the book, so many rules of procedure to help attorneys like me and the defense attorneys and state attorney in this case and the judge know exactly what needs to be done and what findings need to be made in order to make sure that whatever sentence is handed down is a fair and just sentence.
And let's talk about what could happen as far as the sentencing. At most, he could be in prison for how long? What's the minimum?
Sure. So because he's a juvenile, there's kind of a parallel case going on in the juvenile courts. The judge ordered what's called a predisposition report, which has to be considered, and the judge essentially has to rule out the reasonableness and the appropriateness of a juvenile sentence. So the least amount of time he's looking at is probably an incarceration in a juvenile facility until he's 21 years old. The most amount of time is going to be life in prison with a minimum of 40 years at the short end of an adult sentence. And so the judge has to determine if punishment is appropriate in an adult sentence or if rehabilitation is appropriate in a juvenile sentence.
So looking back at data on how often either goes to the juvenile sentencing side or the adult sentencing side, which is more frequent?
So when a child ends up in adult court, it's because the state has certified them as an adult or has indicted them. So it's really one side, the prosecution, making that decision. So the judge, as the referee of any case, really has an opportunity to say, you know what, this child is entitled to be rehabilitated and receive the benefits of our juvenile justice system, rather than just be sentenced as an adult where we basically throw away the key and just let them live their time in prison. It's a great opportunity for a judge to really weigh the facts and circumstances of a child's life, but it's very unusual for a child to be sentenced back to the juvenile courts. I would say, without having the data in front of me, that it's very rare. I certainly don't see it a lot in my practice, but it has happened, and there's some high-profile cases in which it has happened.
So let's talk a little bit more about that 25-year review. So after he's been in prison for 25 years, there is a review, has to be mandated by law. And so talk about the change that he could become. He could be a different person, maybe he's not. The development of a juvenile's brain.
So we already know, and this is part of our federal jurisprudence in the Supreme Court cases, that child brain development does not complete until we're 25 years old. So since he was 14, he has basically been raised by other inmates. We hear in his voice has changed, his accent has changed. That is a product of being incarcerated. And now we know that he's been living in a box in solitary confinement. And so there can be a de-evolution of his mental state. And we don't know at what point he was put on these medications, but certainly he is not developing as a normal teenager would develop if he was not currently incarcerated. And then once he goes to prison, if that's ultimately what happens, he will be raised by other inmates and other convicted murderers and convicted criminals. And certainly that's not the environment where someone's going to maximize their potential as an individual. If he is able to do that in spite of his circumstances, certainly that would be considered in that 25-year review. And they look at the risk level, they look at the victim's next of kin and what their preferences are. They look at whether or not they are sincerely remorseful and if that remorse is sustained, and whether or not they've done anything to rehabilitate themselves, even though the system in and of itself does not seek to rehabilitate.
So you mentioned just now being raised in a box. I mean, he's already been in solitary confinement for quite a while. I've heard people today say, well, after he's sentenced, can he be in solitary confinement again?
Certainly, the executive branch of government, the sheriffs and the wardens control our jails and our prisons, and if he violates the jail rules or the prison rules, absolutely, he could be placed back in solitary confinement. However, there's just no evidence to say that just because he was in solitary in Duval, that he's going to be in solitary elsewhere, and it's possible that the prison experience could be less uncomfortable, not comfortable, but less uncomfortable than his time in the Duval County Jail.
And what does less uncomfortable mean? I mean, it's still a very dangerous environment for a juvenile, right?
Absolutely. I mean, there's a lot of things that happen in prisons, and there's a lot of legislation to protect juveniles and other offenders, but it's not a very exciting existence. And again, our juvenile or our adult criminal system, the intent is to punish. So you're not given any sort of luxuries, any sort of comforts in life. You're given 3 meals a day and a roof over your head, and that's pretty much what you can expect.
So let's talk about if there had been a trial. So we know there's not going to be, but if there had been, I'm sure this was part of the decision on the defense. Mm-hmm. Can we win the case? Mm-hmm. I mean, we never know. You don't know what a jury is going to do, a 6-member jury in this case. Could they have won? Were there holes in the prosecution state? There
were certainly things that, from my opinion as a defense attorney, I would like to have heard the answers to through the evidentiary process, like the blood spatter testimony. How is it that Aiden-Fucci only had a speck or 2 of blood on his clothing? There were certainly questions as to the credibility of the witnesses who are going to testify on behalf of the state. But one of the bigger issues is that he had the right to an appeal before he entered a plea of guilty, and he has waived the right to appeal all of those issues we heard about in the weeks and months leading up to the trial.
So he's waived his right to appeal and to have a change of venue.
Yes.
So yes. He cannot do that at all. Let's talk a little bit more about these blood specks. How would you have expounded on that in court? I mean, if you stab someone, this is horrible, but more than 100 times, mm-hmm. How can you just have a couple specks of blood on your pants? What would you have said to the jury?
Well, that's certainly up to the state to prove the case beyond a reasonable doubt. But if there's a question as to how a 14-year-old boy who's presumably never murdered someone before is able to avoid being covered head to toe in blood when you stab someone 114 times, that is a question that the state would have to answer and explain through expert witness testimony, crime scene reconstruction. And so that would be something as a defense attorney that you would kind of say, that's a question that you need to look to the state jury for an answer, or else maybe there's reasonable doubt that he was not the one to have stabbed her while she was living. And certainly there could be expert testimony about, what happens with blood spatter when someone's alive or not living prior to actually being stabbed.
No, go ahead.
Yeah, and post-mortem versus like ante-mortem stab wounds and the difference between that.
So as far as all these medical photos and the terrible photos, the judge has already ruled some of them out, mm-hmm. but I'm sure that some would be horribly difficult for the family to see. By not going through trial, will that spare the family from having to see some of this, or will the state still present some of these things in the sentencing hearing?
I think at this point, and I've talked to the attorney for the family, that is the one thing that really sticks out in my mind, that this family will not have to endure those photos, and I believe it was 50 photos of their deceased loved one mutilated on a big screen. And certainly saving the family from that trauma is very important to make a point of for the defense. However, the state has to make a decision about the necessity of that, but it's my understanding that the state attorney's office has a very good relationship with the Bailey family, and if it's not necessary, if he's pled to it, at this point, what would be the utility of showing those photos? I think those photos just need to go away and never see the light of day.
So there were some children or some teenagers who apparently noticed his behavior was off, mm-hmm. Not expecting a teenager to think, oh my gosh, he might go as far as murdering someone, mm-hmm. but the kinds of things that he did, the knives that he carried, picker and poker that he named of the things they would do to someone's flesh and all these sort of things. Do we have any evidence that that was ever reported to adults? Is there something to that will be brought up in the sentencing hearing?
This is absolutely what will be brought up in the sentencing hearing. Children do not just wake up one day and murder someone. That's very unusual, especially in a first-degree premeditated situation. There had to have been warning signs, and as a defense attorney, that could be mitigation, it could be good information, or it could be aggravation and used by the state. But I think it's very important to say that if there were other children who were aware of this plan, plan and the possibility that this person could execute this plan, then certainly, why did no one say anything? Why wasn't there intervention at school or with family? Or, those are the real questions that, as a defense attorney, their duty is only to aiden-fucci. So they can certainly call into question the parenting of his parents, the decisions they made as parents, and they can call in to question how the school handled incidents prior to this, to really make the argument that this could have been avoided. And if there is an argument that this could have been avoided, as a defense attorney, that's something you're really going to want to focus on to talk about the failures in the community.
Well, one thing is for sure, everybody called her a ray of sunshine, and you just look at her face and she was so young. And just such a tragedy for the mom and the family, but it's good that the community has just rallied around them. But I always think about this mom in the middle of the night. I mean, I don't know what kind of nightmares she does or doesn't have, but as a mom myself, I don't know you could ever get over that. But that's
Absolutely.
Just the sad reality of what's happened here. So
absolutely, it's certainly a tragedy. 2 lives are lost, 2 families are never going to be the same, and it's just an important reminder that we need the village. We got to watch these kids, and we got to raise these kids right, and hopefully we as a community learn some lessons here.
That's good. Well, we appreciate it. Shannon
Thank you.
Schott, she's an expert on juvenile law.
Yep.
And has lots and lots of juveniles in her experience, and she sees what goes on inside the courtrooms and inside the prisons and the jails and the facilities. So we appreciate what you've been doing, and we'll be back with you when we come to the sentencing hearing February 23rd, which we understand is a Thursday at 9 a.m. Jeannie Blaylock, First Coast News, on your side.